In Port Arthur, Texas, on the Gulf Coast, a company, Sunbelt Rentals, was hired to assist in developing a facility associated with the Golden Pass liquid natural gas project. A Sunbelt worker was assigned to construct a paint storage shed. Although use of a circular saw was a two-person task, at one point, this worker was alone and decided to keep working. Holding the circular saw in his right hand and the board in his left hand, he executed a cut. The saw jumped, cutting into his hand, severing tendons and bone, and sending the worker to a nearby hospital. When OSHA conducted an inspection, it issued a citation against the employer for failure to instruct each employee on how to recognize and avoid hazards associated with usage of circular saw. Today, we'll discuss OSHA's citation, Sunbelt's defenses, and the judge's decision, and what it means for you, employers, in our OSHA 3030 community. I'm Manesh Rath, and this is the October 2025 edition of the OSHA 3030. Well, hello, everyone. As I said, I'm Manesh Rath, and I'm a partner at the law firm Keller and Heckman here in Washington, D.C. And for 30 years, I've been representing management side in the field of OSHA law, amongst other areas. And I'm grateful today because I'm joined by my friend and colleague, Ben Idzik, one of our OSHA attorneys here at Keller and Heckman. Ben, welcome to the OSHA 3030.
Thank you, Manesh. Great to be on, as always.
It's great to have you here. Well, we've got a great topic, Ben, and I think we should get cracking on what the case is and what we're going to talk about today.
Yeah, let's do it. So we will begin with a overview of the facts of this case. We're going to cover the background of Sunbelt Rentals, what happened in particular with the incident, what OSHA's inspection and citation look like, and specific to this case, we're going to cover Sunbelt's safety program as it's going to be important moving forward.
Right. And then we're going to talk about what it takes for OSHA to establish a violation of a specific standard, OSHA's allegations, Sunbelt's decision to issue a notice of contest and what its defenses were, and the ALJ's decision in the case styled Secretary of Labor versus Sunbelt Rentals.
And as always, with what employers in the 3030 community should do based upon this case.
That's right. I think that it's critical that, as we've been doing for about 13 years, every single month, to allow our OSHA 3030 community members to walk away from this program with something practical, a takeaway item that you can go back to your organization and maybe implement, make the safety and health program just a little bit better, make your legal defenses a little bit stronger. All of our prior episodes are stored on our website, khlaw.com/OSHA 3030, and 13 years worth of episodes are stored there. You can catch them both as a podcast. You can catch the audio or the video and audio with the slides by going to our website and looking them up. A lot of information, even though it's 10 years old and older, still extremely valuable. So check it out. And don't forget to subscribe to the podcast so that it just downloads and you can catch it on your commute. And the last thing I'd say is if you haven't done so yet, please connect with us on LinkedIn, both Ben Idzik and myself, Manesh Rath. We all, as well as Keller Heckman's Safety and Health page, have LinkedIn pages. Finally, as you know, when you get this invitation by email, please, if you can, forward it on to 3 people within your organization and at other organizations, in-house counsel responsible for OSHA compliance and safety and health professionals, so that we can spread the good word about the good content that we create here for friends and clients of the law firm Keller and Heckman. So thank you for doing that for those of you who have continued forwarding that email on to 3 people. So facts of the case, how do I get started? I think it starts with Sunbelt, an equipment rental company all over the country, a fairly significant, large company with a large corporate presence nationwide.
Yeah, it is about 2,300 employees. So like you said, pretty significant. And what Sunbelt does, as its name suggests, is that it rents out equipment, power equipment, HVAC equipment, and temporary structures for construction projects, things like scaffolding, tents.
Right. And in this case, a little bit different project. They were hired to construct a paint shed at a site associated with a liquid natural gas project there in Port Arthur.
Right. And the 2 employees that were assigned to this project, one of which was the injured employee whose name was redacted in the decision, and his colleague was a gentleman named Joseph Matthews. And what this paint hutch was is just a structure to store paint away from the weather.
Well, that's right. And the first task they were supposed to engage in constructing that paint storage shed was the flooring, and that involved hand cutting planks of wood to create the decking or the flooring for that paint shed. So they were assigned to conduct that task with the use of, amongst other things, a circular table saw.
So the actual morning of the incident, Matthews and the injured employee participated in a tailgate meeting. So the tailgate meeting involved the foreman of the project informing the workers about what they have to do, and it also included a safety component that was memorialized by a written job safety assessment. And in the assessment, the foreman cautioned the workers about the need for the use of a DeWalt circular saw, um, and provided the workers with some instructions to avoid the hazards associated with it.
That's right. And this job safety analysis is conducted by Sunbelt every day or every time a new task is begun. And they do a job safety analysis, identify the hazards, and make sure employees are warned and apprised of the hazards associated with it. He also asked at that particular JSA meeting or tailgate meeting who had experience and knowledge on how to work a circular saw safely.
Right. They both had some experience from prior job experiences of using these kinds of saws. And then once the project actually began, the foreman for the initial part supervised the two employees and ensured that they were comfortable with indeed using the saws. And at the beginning of the project, everything appeared to be going smoothly and all proper safety procedures were followed.
One of the things that you mean by that, Ben, is that for a significant amount of time, and while the foreman was supervising the work, the two employees were doing this using a two-person engagement. One person was holding the material down at a distance. The product was well supported underneath, and one of the workers was holding the material down, bracing it, and the other worker was operating the circular saw, allowing that worker to use a two-hand operation of the circular saw.
Exactly. And when things went tragically wrong in this incident was when, like you mentioned at the beginning, Manish, the other employee left, and the injured employee attempted to cut the piece of plywood with holding it with his left hand, having the saw in his right, and in that process severely injured his hand, which required hospitalization, which then Sunbelt reported to OSHA, which conducted an investigation.
Right. Circular saws have their own unique hazards associated with them. Some of them are well understood by workers who work with them, but it's important to conduct that training, starting with the examination of the equipment, make sure the teeth are straight and not dull, to make sure that there's no warping or deformation in the arbor or in the spindle, or that the spindle is clamped down and not wobbling. I think the other part of it is to make sure that the product is well supported underneath, that the cut is taking place close to a support, and that the long end is under the support, and that the waist side of the cut doesn't need to have support under it. But in addition, I think the product needs to be braced, either clamped down or braced in some other fashion, because all of these steps are designed to allow the operator of the circular saw to do two things that are critical for operator safety. One is to prefer the use of two hands on the handle of the circular saw so that they're out of the way of danger. And the other is so that during the entire duration of the cut, that the worker is at a safe position, preferably off to one side, and as he leans forward through the cut, or she leans forward through the cut, is not putting the worker or the cabling in any path of hazard. And so these are the kinds of techniques that are deployed in order to assure those two critical features of a cutting action. Then there's the base plate or the sole plate of the saw, and that should at least be partially resting on a supported part of the product rather than on entirely resting on a hanging part of the product, because as the cut gets finished, the whole sole plate will then have no support and will fall with the waste end of the product, and that also has the potential to throw a worker off balance, in addition to possibly damaging the product, splinters. But all of these are sort of the safe methods by which a circular saw or handheld saw is supposed to be engaged, and that's what they were doing during that first step.
Right. And as soon as that ended, that's where things went wrong. So after the injury was reported to OSHA, an inspection was conducted on site. The compliance safety and health officer arrived. He conducted an open conference with Sunbelt's counsel, conducted employee interviews, including of the Matthews and the injured employee. They also reviewed and collected Sunbelt's safety programs, all the safety material and training materials, and also inspected the site of the actual injury. I think the initial finding, one of the first conclusions that the officer made was that there were no deficiencies with the saw itself.
That's right. The saw was in good shape. All of the parts were fastened securely. That was a critical first step, and I think that that is one of those first steps that you have to do at the beginning of every task. And in addition, it's one of the first things the compliance officer looked at. Um, what are the other things that the compliance officer did as they walked through their investigation?
Right. So the compliance officer, I think, critically conducted and recorded interviews of the injured employee and of Matthews.
And of the foreman, if I'm not mistaken.
Yes, of the
Yeah.
foreman as well. With respect to the injured employee in Matthews, the compliance officer's notes recorded that they received training generally, but the compliance officer specifically noted that they did not receive training on saws specifically.
Well, that's right. And that's a very critical fact as the case developed into the trial stage. Matthews was one of the people testifying and testified that he did receive training.
Right. That was what I think played out later on that ultimately resulted in this case being found in Sunbelt's favor.
And so did the foreman. The foreman testified and said, yes, we have the following training program, and it includes safe use of the circular saw, and that both the injured employee and Matthews received that training,
Yeah.
which is consistent with Matthews' testimony.
Yeah, I think that this OSHA's like most of OSHA's case rested on these notes. Sunbelt had as we'll detail in a moment here, Sunbelt had a very extensive safety program that included all these measures that you mentioned, Manesh.
Right. Essentially, and his testimony at trial, essentially both amounting to that there wasn't any training, at least where it regards Matthews and the injured employee, with specific application to the question of safe handling, recognizing hazards, and safe handling of that circular saw. The compliance officer testified and said his interview notes bore him out that there wasn't that required training, requisite training.
Right.
I should point out, before we get into Sunbelt's defenses, Ben, that this was issued under a specific citation of a specific standard that's under the construction standard, which requires that each employee be trained to recognize and avoid any hazard associated with any task they're performing. It's a very broad standard, but it is also, by being so broad, very minimal in its specific expectations. It only says that each employee needs to be trained on recognizing and avoiding hazards with the tasks that they're to perform.
Right. And as you mentioned, this is a standard that's specific to the construction industry, which OSHA maintains a dedicated set of standards for construction specifically and separate standards for general industry.
That's right. And to our many friends in the OSHA 3030 community who are in the general industry section, I would point out that many of the standards have training components specifically written in as a subsection of those standards. All of the health standards have training components, for example, and many of the safety standards as well.
Right. So in terms of Sunbelt's safety program, had several components. Like we mentioned, it was a pretty robust program, and we can go through a couple of the highlights of what it included. The first is that it included a safety campaign called Engage for Life, whereby which employees audit the safety practices at work sites.
So that's interesting, Ben. What they had as part of their quote Engage for Life program was that workers would observe and evaluate the safety, the level of safety of the practices of their own coworkers, either at their own job site or at different job sites. And they were asked to comment on the safety observations that they were making about their own coworkers. I think that that is a rather less used. I think it's a great idea, and I think it's prime for going mainstream because it's just something that seems to me intuitively to have a high degree of effectiveness. And so I applaud that very, unique and maybe creative thinking sort of element of their quote unquote engaged for life safety campaign.
Yeah, certainly, and it shows that, like we mentioned, Sunbelt did have safety in mind when it in terms of how its employees were trained. The program also included routine tool monitoring components. So it shows, consistent with what the compliance officer found, that the tools were regularly inspected, including this tool that was used that ultimately injured this worker in this case. The Sunbelt safety program also included sort of general things that we find commonly amongst other employers, including new employee orientation. The new employee orientation was actually administered by the Houston Area Safety Council as a third-party provider.
So new employee orientation with specific respect to safety.
Right. Yeah, with
Yeah.
and
And produced by or offered to delivered by a safety council.
Yeah, exactly. And that training included training on the use of hand drills, hand tools such as drills and saws. And also, the safety policy included a policy manual that Sunbelt maintained, and that manual had a dedicated section on power tools. And also, interestingly enough, Sunbelt also would conduct weekly safety reviews. They would send out weekly informations on best safety practices around the work site to employees.
Right. And as we talked about before, Ben, they conducted job safety analyses at every the start of every shift and when new tasks were commenced, and they would train employees on those job safety analyses so that employees understood where the hazards were that were identified in the JSA, as well as what safety precautions needed to be taken. And that was incorporated into their morning safety briefings, their tailgate meetings.
Exactly. And I think one of the important things that comes up in the actual decision is this routine task JSA on circular saws. This is something that Sunbelt adopted in 2017 and was specifically devoted to the hazards associated with using circular saws and how to mitigate the hazard posed by kickbacks, which ultimately resulted in the injury in this case. So um, when this comes up before the ALJ, the ALJ was then able to really hone in on this particular fact.
Right. And then, of course, in addition, as we said before, they're regularly monitored for compliance with their safety policies and actively enforced those
Mhm.
expectations. So we've talked many times, Ben, here at the OSHA 3030 about if OSHA is issuing a citation under a specific standard, what are the four elements that they need to establish in order to secure an affirmation by an administrative law judge of the citation. So we won't go into them right now, except for to say that you have to look very carefully when defending against a citation to see that all four of them apply. Here in this case, Sunbelt believed that the terms of the standard, the specific requirements of the standard, were met by Sunbelt. OSHA has to prove that the requirements of the standard were violated amongst three other elements. And Sunbelt believed that that was the one that OSHA was missing, and accordingly presented evidence in defense of itself that it did meet the requirements of that specific construction site safety standard to make sure each employee recognizes and knows how to avoid hazards associated with their tasks.
Right. So in terms of what OSHA specifically alleged before the ALJ, um, OSHA argued that Sunbelt's safety training with respect to circular saws was too generic to properly inform employees about the hazards that they posed.
The idea being, according to OSHA, you can't just say, hey, circular saws are dangerous, be careful.
Exactly, exactly. They thought that the program was just insufficient, and that's what caused the injuries in this case. Um, they also discussed the routine JSA that Sunbelt created in 2017, and it found that was insufficient because it did not specifically address the hazards of kickbacks. And they also made certain points about how on a procedural kind of argument, the Sunbelt's, OSHA's attorneys argued that the court should infer that the employees were not aware that this JSA existed because one of the employees who testified, Matthews, never confirmed its existence at trial.
Interesting production of evidence in its own support of its allegation that there was a violation. Sunbelt's defenses were pretty much the obverse of OSHA's allegations. For one thing, they pointed to their safety training and said, when you look at the content of the safety training with specific respect to circular saws, that it was consistent with what other reasonably prudent employers were providing. And in addition, they pointed to the specific details of their circular saw safety training when they were discussing it in their general safety orientation provided by the Houston Safety Council, when they discussed it in their tailgate meetings, and the details that they had identified in their JSA, their written JSA, their job safety analysis, and identified all of the specifics that were by a far step away from just being a generic warning and actually dealt with the particulars of how to handle circular saws safely. So that's the first thing they did to counter OSHA's allegations.
Right. And then with respect to OSHA's allegations that the 2017 JSA didn't discuss kickbacks, Sunbelt cited the exact language in that JSA and said that operators should ensure the sharpness of blades, using both hands, standing on the side while cutting, never holding the wood in the air while cutting with the saw, and argue that these actually expressly, plainly address the hazards posed from kickbacks.
That's right. They're all measures designed to avoid risks associated with kickbacks or skipping. Right. And the compliance safety and health officer pointed to his interview notes saying, well, these two employees, Matthews and the injured employee, they said that they were never trained. But Matthews did. So what Sunbelt did was they put Matthews himself on the stand and had him testify. And his testimony at trial was that he did receive safety training with respect to circular saws. And that was corroborated by the foreman's testimony as well about all of the training that employees, including Matthews and the injured employee, received with respect to circular saw safety.
Yeah, and I think critically with respect to the interview notes, Sunbelt pressed hard in the fact that they were not verified, meaning they were not signed or initialed by Matthews or the injured employee, questioning their actual accuracy.
Right. It's possible that the compliance officer misrecollected when at the time he took notes, or misheard the employee at the time that the employee testified, and that an important step that a compliance officer can take, is not required to, that I know of, but could take, is to finish their notes and present them to the employee and ask them if there's anything in there that was inaccurately transcribed or that is deserving of correction, and have the employee sign the final version after any number of revisions that the employee wants to make to say, yeah, that is testimony that I'm comfortable with, then to have them sign it to validate or authenticate the compliance officer's notes. Again, this is an option for a compliance officer, but if they don't do so and then merely testify as to what witnesses said, it does fall under a quality of evidence problem where it lacks the same probity that you might see from a live witness testifying at trial. So let's talk about the administrative law judge's decision, having heard both sides. The first thing that the ALJ noted in their decision was that the judge believed that Sunbelt's safety training was not generic, that it was sufficiently specific. It looked at the elements in the job safety analysis. It looked at the elements in the written job safety analysis and the poster, as well as the content for the general orientation provided by the Houston Safety Council, and believed that there were elements in this training with respect to the use of a circular saw that were sufficiently specific, both in the question of recognizing hazards as well as hazard avoidance.
Exactly. And the ALJ also noted that the injured employee and Matthews received specific instructions on circular saws during the morning tailgate meetings with the foreman, that if followed would have avoided the injury in this particular case. And like we discussed earlier, Manesh, the foreman did say to make sure you're using both hands to brace the board with the partner, using things like using eye protection, all of which the ALJ found persuasive as putting both employees on alert of the hazards posed by circular saws.
That's right. The other thing the administrative law judge noted, the OSHA compliance officer had testified that the job safety analysis on circular saws The OSHA compliance officer believed it didn't really specifically address kickback hazards. The judge said when he examined the job safety analysis that he believed it did specifically and directly address kickback hazards. Things like don't hold a board with one hand and cut with the other are designed to address kickback hazards, and several others, clamping of the product or bracing it, using support underneath, are all specifically designed to address kickback hazards. And so the judge believed that the evidence was in the record, that there was specificity with respect to not only safe use of circular saws, but specifically kickback hazards.
Exactly. And the ALJ also discussed how he agreed with Sunbelt's arguments that the compliance officer's interview notes were unreliable, and when compared to the testimony of Matthews and of the foreman in this particular case, could not overcome that testimony.
I thought this was one of the more important parts of the judge's decision, that he said, in general, the in-court testimony will be given greater weight than a compliance officer's interview notes if the interviewee is not present, for example, or if the interview notes are not verified by the employee, that they had an opportunity to correct and verify or validate them. Ultimately, on account of that and all of those points that we just discussed, the judge vacated the citation. OSHA walked away empty-handed, and Sunbelt was vindicated in its decision to contest the citation. Okay, well, before we go, why don't we talk about what employers should do? What I think is the critical part of the program. What takeaway items can we walk away from the Sunbelt case, Secretary versus Sunbelt Rentals, and implement into our own workplaces to make them just a little bit stronger?
Right. I think one of the first things that you can see is from the beginning, the daily tailgate meetings. Having the opportunity to sit down with your employees and address anticipated hazards of the work they're about to perform, and the tasks to get everybody on the same page and alert them to what is any dangers that they might face.
Right. One takeaway item I was impressed by, as I said earlier, was the JSA specific posters that were posted up for employees in the break room so that they could take the time to read it thoroughly again at their own time.
Another reason, always make sure to document. This is something that I think we discuss all the time with clients, friends. Without documentation, you don't have the same level of position to be able to show that you implemented the measures that in fact you did implement.
Right. And again, if you think of them as the big three of training, identify the material and record it, keep it in records, who attended, and then some kind of mode of testing for comprehension. I'd say that the next thing is the importance of not only designating an individual. We've talked about this for so many years on the program, on the OSHA 3030, designating an individual that accompanies the compliance officer during the site inspection, but also make sure that that person takes duplicate records as those that are taken by the compliance officer, observations, testing, sampling, photographs, or other imaging or recordings, what questions they ask, what records you supply them should be recorded, et cetera. And so that you have, at the end of the inspection, a good record of how the inspection went down. And if there's any contradiction between the testimony of the compliance officer and your notes, that you have a basis for knowing how to present countervailing evidence.
I think another takeaway point here is just the importance of witness testimony, especially with situations where the compliance officer may get something wrong in his or her notes. Having employees come forward and testify, and having your own sort of records of that you can gather on your own terms to back that up, I think would be an important step to take.
I thought this was one of the takeaway items, that what employers should do segment from the September OSHA 3030. I could have recollected that incorrectly, but if so, I hope you're picking up on a trend here, that an employer will fare in his citation contest or her citation contest will fare well directly in proportion to the quality and the quantity of evidence supplied at the hearing, and that there's no opportunity for cutting corners without also sacrificing your chances of prevailing upon the judge the bona fides of your arguments. The witnesses that Sunbelt took the time to present at trial, in the end, made a huge difference in the outcome.
Exactly. And I think the last point, and this is again one that we frequently discuss, ensure that you're actively enforcing safety policies. Discipline is key. And I think in this case, what was interesting that was noted in the decision was that despite having an injury suffered, the injured employee in this case did receive coaching from Sunbelt after the injury. which shows the importance that in the company's eyes safety has.
Yeah, I think it's one of the harder things for folks to do to discipline somebody after they've gotten injured and hospitalized. You would think that maybe they've already been punished enough by force of their injury, but I think it's important to preserve the efficacy of a company's compliance program to register that disciplinary coaching or counseling event, regardless of whether the employee was injured or how severely the employee was injured, if indeed it was a disciplinary event. Well, that's this month's OSHA 3030, the October 2025 OSHA 3030. We'll meet you again on November 19th at 1 p.m. Eastern Time for the next episode or edition of the OSHA 3030. Thank you all for joining. We'll say two more things that are really critical. Our sister programs, the REACH 3030 and the TSCA 3030, are scheduled for December 10th at 10 a.m. and 1 p.m. Eastern United States Time, respectively. Please check those out. Great programs, and forward on information about the REACH 3030 and TSCA 3030 to folks within your organization that are responsible for compliance with those laws. The other thing I'd say is, again, as I started saying at the beginning, please forward this invitation on when you get it for the November 19th edition of the OSHA 3030. Please forward it on to 3 people within your organization and at other organizations, in-house counsel, safety and health professionals, anyone else responsible for helping make your program just a little bit safer. Thank you all here in the OSHA 3030 community for participating with this month's edition. I want to thank the staff here at Keller and Heckman for all of their work in putting this program together. And on behalf of Ben Idzik and myself, we're grateful to you all for continuing to help make this program stronger every year. We look forward to seeing you again next month. And until then, stay safe.